Welcome back to another episode of Grizzly True Crime. My name is Gisela K, and today we're going to be looking at Judge Gull's response to Richard Allen's petition for a writ of mandamus. We were waiting for this. The deadline was set for November 9th, which then became the 16th, which then became the 27th, and that was it. Judge Gull has not been feeling very well and has apparently been in the hospital and working from home. So we were all wondering if she was going to be able to respond. Right before this document came out, another document came out where the Attorney General responded. So that was interesting because the Attorney General had chosen not to represent Judge Gull in this matter, which, from what I've seen, legal experts say would be the ordinary thing to do. And the Attorney General said that this petition for a writ of mandamus should be denied. Okay, so this is now Judge Gull's response. In the Supreme Court of Indiana, the state of Indiana, ex rel. Richard Allen relator versus Carroll Circuit Court and the Honorable Francis C. Gull, Special Judge, respondents. Respondents' brief in opposition to relator's verified petition for writ of mandamus. If you haven't been following along with all the documents, there is a link in the description box to the playlist. I hope you'll catch up on that because it's been a lot of back and forth between the defense attorneys, the judge, of course, the prosecutor, and at the end of the day, everybody just wants a fair trial for the suspect, Richard Allen, so that there can be true justice for the victims, Libby German and Abby Williams. All right, so table of contents. I'm just going to skip through that because we're going to get to all the contents right now. This document is 23 pages long. You can see there's a lot of legalese in it. And remember, I'm not a lawyer. So we're just going to read through it as the public, as a mock jury, right? So introduction. This court has never issued a writ do you want it bigger like this? Okay. This court has never issued a writ to reinstate a criminal defendant's counsel whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. In disqualifying relator's counsel, the respondent did not violate an absolute duty. Moreover, the relator's remedies on appeal are wholly adequate. Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice through the ordinary appellate process. Whether the relator's counsel withdrew or were removed, this court should deny the petition. The relator's petition further fails on the merits. Relator's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select his counsel. The respondent has discretion, so Judge Gull has discretion to remove Richard Allen's counsel where, as here, the record supports that attorneys Baldwin and Rosie were providing ineffective assistance of counsel. Relator's counsel, 1, failed on multiple occasions to take reasonable steps to safeguard confidential case materials. We can't argue with that. It happened from what we know. Based on what we know, it seems like there was a bit of a weak link with defense attorney Andrew Baldwin's, conference room that the defense attorneys called home base and putting pictures out on the conference table and leaving them out and trusting a friend with that. So they said 1 is failed on multiple occasions to take reasonable steps to safeguard confidential case materials, and 2 made extrajudicial statements that had a material likelihood of prejudicing the case, and 3, providing false information to the court. Interesting. Before removing the relator's counsel, the respondent, Judge Gull, afforded Richard Allen, I'm just going to say it like that so we can follow along, right? Afforded Richard Allen with notice and opportunity to be heard through written submissions, as well as argument in chambers and on the record in open court. Now, to that, I will just say, in my memory, the defense attorneys asked if Richard Allen can speak his mind, and Judge Gull said she wouldn't be comfortable with him in her chambers, and also that the Department of Corrections would likely not be comfortable with that. So, by the way, this video is coming from a members-only stream, so thank you, members, for bearing with me. We were just chatting about a whole bunch of other cases. I just want to read through this and make sure that everybody gets this news and goes through. We can go through this document. So thank you so much for your support. I will read your comments afterwards. Okay, relator's request for this court to disqualify the respondent. So remember, Richard Allen's attorneys, Bradley Rosie actually, filed a motion to disqualify Judge Gull. So they say the relator's request for this court to disqualify the respondent fails because the respondent alleges no bias or prejudice against the relator or his current counsel, which I think majority of the public will beg to differ because it doesn't feel that way or seem that way. But it's just based on what we know and what we're seeing, right? Relator's lone assertion for respondent's removal is the trial court's ruling to disqualify the relator's prior counsel. But a trial judge's adverse rulings are insufficient to demonstrate the judge has a personal bias or prejudice. This court should deny the petition. So, Tiff Knox said, what was that about? He's supposed to be innocent until proven, so Gull should be fine with him in her chambers. Yes, now Barbara said, highly inappropriate for a defendant to be in the judge's chambers. So we've got lots of mixed reviews coming in so far. We're on page 7 out of 23. Also, Kerry said, but she didn't have an actual inquiry. As a judge, it's not up to her to make a decision without hearing their side on the record too. And I think that's one of the biggest issues. It's almost like she was trying to be nice to the defense attorney and be like, listen, you guys have a private conversation. You just see yourselves out. And it seems like that obviously it didn't go well because it's just made more and more and more of a mess because that's not the way to do things. There is a way to do things. And from my understanding, there's a procedure. They've got to have notice to be able to have a hearing. And from the Attorney General's response that I'd read through, not with you now, but before this live stream, that response was saying that, but they were there. They could have presented their case at, and argued it at that hearing on October 19th, but they didn't know that that was going to be the subject matter from what we're reading, right? Okay, so they say a trial judge's adverse rulings are insufficient to demonstrate the judge has a personal bias or prejudice. This court should deny the petition. Standard of review. The Supreme Court has the power, by writ of mandate and prohibition, to confine a lower court within its lawful jurisdiction. Then they give a lot of references. Writs of mandamus and prohibition are extraordinary remedies, which are viewed with disfavor and may not be used as substitutes for appeals. This is very similar to what we've read before, where the judge is basically saying, and the Attorney General as well, that this was not the right way to go about it from the defense's side and from Richard Allen's side, that this shouldn't be a substitute for appeals. Joanna Newberg says she overdid it and it backfired. That summarizes what I was trying to say, yes. So they say this court will not issue a writ unless the relator has a clear and unquestioned right to relief, and only where the trial court has an absolute duty to act or refrain from acting. Argument. Oh, you're getting to the argument part. Here we go. The relator's petition fails the mandatory procedural requirements for seeking a writ. A. The relator does not have a clear and unquestioned right to have his counsel reinstated. This court has never issued a writ to reinstate counsel where, as here, the trial court removed counsel based on the court's reasonable findings that counsel had engaged. But you see those findings, what are they? Judge Gull always talks about her findings, but no one knows what they are. That's what defense attorneys are also saying, like the Defense Diaries podcast. What are these findings? It's as if she did her own investigation and there's these reasonable findings. So I get what she means if I just read it as is, but I think there's supposed to be a hearing and the public's also supposed to know, well, what did they do? Exactly, right? So then they said that they had engaged in multiple acts of gross negligence, compromising the accused's constitutional right to competent assistance of counsel. And contrary to the relator's assertion, neither this court nor the United States Supreme Court has held that a trial court may remove an accused's selected counsel in two circumstances only: where 1, counsel is not a member of the state bar, or 2, counsel has an actual conflict of interest. See relator's brief in support of petition for a writ of mandamus, hereinafter brief, at 15. The relator does not have a clear and unquestioned right to the relief he seeks. Interesting. I also heard from legal experts, they're all over X and they're on YouTube and everything. There's law tubers, right? And I watch a lot of that to learn as much as possible. That was a bit of a gray area when Attorney Bradley Rosie did not actually file his written motion to withdraw. That was a bit of a gray area, and then offered to work pro bono. It seemed like that could be a transition for him to continue to stay on the case, from what I'm understanding. So to the contrary, this court in state, and here they give references, denied the relief the relator requests here. In state, ex-relator Jones, the relator, who had been indicted for murder and SA, requested a writ of mandamus to reinstate his attorneys, whom the trial court had removed. The court denied the petition. In dictum, the court observed that it was generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. However, the court finds it unnecessary to explicate the parameters of that authority here. The court's dictum in this case, a different case they're referencing, does not provide the relator with a clear, unquestioned right to relief or establish that respondent violated an absolute duty. The relator relies for the most part on cases from outside Indiana. Okay, the relator, Richard Allen, relies for the most part on cases outside of Indiana. See petition at brief page 15. But these cases are not binding on the trial court, much less do they impose on respondent an absolute duty to act. When interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. And I can't wait for them to respond again. What will the Supreme Court say, the Indiana Supreme Court? And what are Richard Allen's civil case attorneys going to say? Because we looked at the document last time and there's 3 of them, from what I'm understanding. Okay, so they say they must follow the law of Indiana's appellate courts and the United States Supreme Court. The relator identifies no case from this court or the United States Supreme Court that affords him a clear right to an extraordinary writ for the relief that he seeks. The relator's remedies by appeal are wholly adequate. Okay, all petitions shall state facts showing clearly that the remedy by appeal will be wholly inadequate. Far too frequently, writs of prohibition and mandate are sought to be used as a shortcut to an appeal on the merits which cannot be undone. So that's similar to what they said earlier. If relator believes that cases from other jurisdictions are persuasive in how the respondent should interpret the Sixth Amendment, the relator may present those arguments on interlocutory or direct appeal. The relator cannot file an original action to circumvent the normal appellate process. And then they give a lot of legal references, which, as you know, I'm not a lawyer, so I think attorneys would have a good grip on what all of these references are. What I'm understanding as a South African living in the Netherlands and not a lawyer is that, of course, they're responding and building their case and saying, well, you reference these, now we're going to reference these. And so basically they want this petition for a writ of mandamus to be denied for all their reasons, and it all sounds the same, doesn't it? It's this back and forth that all sounds the same. I'm sure there's differences. I'm sure that lawyers will pick up all the tiny differences, but oh my word. It's kind of just like, of course, it's just arguing now. That's what happens in court, but one would hope it wouldn't happen with a judge and these defense attorneys and Richard Allen, the suspect. This is very sad for the case. In my opinion, how things have gone, I'm sure you all feel like that. The trial was supposed to start in January, and now it's just been shifted to October 15th of 2024. That's a long wait. Not only for the suspect who's in prison, but not jail, like ordinarily, because they say it's for his safekeeping. That's also in question. But for the families, oh my word, just like another year. It's horrible, isn't it? Kerry said, in other words, there's nothing stopping a judge from doing what the heck she wants until being through court and to appeal. I'm very interested to see what the Supreme Court will say, because at this point, it's like watching a table tennis match, just like back and forth, which I know is part of the process, but my goodness, it's the same stuff we've heard, right? Relator asked this court to use an original action to rule for the first time in Indiana that the Sixth Amendment, prohibits a trial court from removing counsel whom the trial court has reasonably found to have been grossly negligent. But this needs to be explained more than they leaked crime scene photos or they put out a press briefing when there was a gag order, right? So they said, but this court will consider an extraordinary writ only when the law is settled and the trial court's duty is absolute. This court should decline the relator's invitation to use an original action to alter Indiana law. 2. The trial court did not violate the relator's Sixth Amendment rights by removing relator's counsel. Now this should be interesting to hear. Let's hear what they say. A criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. The Sixth Amendment to the Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant rather than to ensure that a defendant will be inexorably represented by the lawyer whom he prefers. Okay. Thoughts? I wonder if the judge will have to recuse herself or what is going to happen next. Robin E. says this whole mess is to help the prosecution because they are not ready for trial. Nicholas McClelland is shaking in his boots. I mean, he did say it himself. He's like, they're going to make deep fakes. He doesn't want cameras in the courtroom from what I remember, right? And he's like, they're going to make clips out of context. It sounds almost like these YouTubers are going to make YouTube shorts out of this and deep fakes. And it's like, wait, what? Like, what are you paranoid about, Nicholas McClelland, the prosecutor? There's bigger things to worry about, as we can see now. Okay, so A, the respondent properly exercised her discretion to protect the relator's Sixth Amendment right to effective assistance of counsel by removing Baldwin and Rosie. So Judge Gull is saying that she protected Richard Allen's Sixth Amendment rights by removing this ineffective counsel. I think the whole argument, everyone's been up in arms because people were saying that his Sixth Amendment rights have not been protected by her actions. Yeah, Heather says TikToks. That too. He's probably scared of TikTok, yes. So, as this court has explained, the right to counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. So it's like he has a right, but not an absolute right, okay? The appointment of pauper counsel is within the discretion of the trial court and will be reviewed only for abuse of that discretion. The qualified right to choose one's own counsel must be placed against the backdrop of judicial discretion. Traditionally, courts enjoy broad discretion to determine who shall practice before them and to monitor the conduct of those who do. The Sixth Amendment right to choice of counsel merely informs judicial discretion. It does not displace it. The trial court is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused's Sixth Amendment right to competent and effective assistance of counsel. This court has explained that the trial court must be given latitude in its efforts to navigate the Scylla. Oh, these are big words now for me here, for legal words. I mean, like the Scylla and Charybdis. No, you couldn't hear the French come out. Must we say Scylla and Charybdis? Anyway, sorry, lawyers, are your ears hurting? Posed by the conflicting Sixth Amendment rights to counsel of one's choice and to competent counsel. We conclude that trial court discretion is necessary because the tension between these two important rights must be resolved by the trial court. Gross incompetence or contumacious conduct that cannot be cured by a citation for contempt may justify the court's removal of an attorney. I mean, these words, it's just escalating and the accusations are escalating. That's what I'm hearing, right? Stefan says, not very strong arguments by the seagull, in my opinion. Right? Big words, lots of references, and just saying the same thing in a different way. Yeah, Joanna says, lawyers in the den, please explain. If there's lawyers in the den, please do. All right, so as we read, we're on page 11. So, gross incompetence, yes, we were there. They say, yeah, moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. We must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. With a reference. Okay. Affirming disqualification of defense counsel on the grounds that the trial court has an obligation to foresee problems over representation that might arise at trial and head them off beforehand. The trial court retains the discretion to remove counsel to preserve and accuse constitutional rights to effective assistance of counsel and due process. Well, that's what we're all arguing about. Exactly that. It's so weird to hear the judge say it now. The trial court retains the discretion to remove Baldwin and Rosie to preserve Richard Allen's constitutional rights to effective assistance of counsel and due process. But then it looks like she picked her Facebook friends. That's what made it so weird as well. Like the new attorneys are like, wait, what? Oh, anyway. Okay, the respondent acted well within her discretion to remove Baldwin and Rosie over the relator's objections. I must just say, quickly, because this video is going to be public after this live stream, of course, I will clip this for us. And so somebody's going to say, so what if they're Facebook friends? Well, in other states, it's a big so what, and some judges have had to recuse themselves over their social media connections. All right. Yeah, Candy says, on all this time, Richard Allen is sitting in prison. Just think, if he's innocent, what this has done to him. Can you imagine? I mean, I always remind people, what if that was your husband, your brother, your son, your friend, anyone you know in that position? It's not like it's never happened before. Oh, thank you. Stefan says, the between those means something like to choose the lesser of two evils. Okay, so the respondent acted well within her discretion to remove Baldwin and Rosie over the relator's objections. The record supports that the trial court could reasonably conclude Baldwin and Rosie committed multiple violations of the rules of professional conduct, compromised the relator's defense, and that the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. All I'm going to say is it's not nice or professional for the photos to have leaked. But they didn't have knowledge of it from what we know. It was a friend who obviously was motivated by what? I can only think of money, right? Why would this friend do this to Andrew Baldwin and then pass it on? And then that person took their own life, and they'd passed it on to someone else and all of that. You know what I mean? So how the question I have is, how does that compromise Richard Allen's defense? That's what I would like to know. Do you know? And it's just odd hearing the judge, speaking like this. I don't know how to say it. It's just like, wait, what? So you're trying to protect Richard Allen, but it doesn't look that way. It doesn't seem like it from everything that we're reading and hearing, right? Maybe it is, but who knows? So here they say, Baldwin and Rosie committed multiple violations of the rules of professional conduct, compromised the relator's defense. How? And that the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. To me, I just think they shook up the prosecution. I think they made the state's burden much heavier. They realized, oh man, we're going to have to prove a lot here. So, 1, Baldwin and Rosie failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. Baldwin's friend and former employee Mitchell Westerman went into Baldwin's office and conference room, reviewed confidential photos of the crime scene, took pictures of those photos, and shared them with at least one other authorized person. The photos leaked to the public, which prompted the police to investigate. An individual with whom Westerman shared the confidential photos committed suicide the night after police questioned him. Wow. The night after. Sure. MKO says this is one big web. Yeah, it really is. Carla said, and she's a special court-appointed judge. You would think she would take that with honor. So they said an individual with, okay, so he shared it, and okay, we know about that. Rosie and Baldwin agreed to use Baldwin's conference room as home base for confidential case materials, record, volume 1, page 214. Rosie understood that Westerman would regularly visit Baldwin's office and that Baldwin would share with Westerman information about the case to obtain Westerman's feedback. I had some attorneys email me to say that's actually pretty normal to talk to your legal friends and strategize. I don't know if it is or isn't. That's what I got an email. The Angel Rock with Lorelei says, yes, G, I wondered if the leaker was either paid or forced to leak those photos so the defense could get disqualified and a chosen defense could be put in place instead. So many questions, right? Now, two, they say Baldwin, now this was a mistake, but I've seen a lot of lawyers argue it's still not gross negligence, but listen to this one. Baldwin emailed confidential work product to an unauthorized person, and Baldwin and Rosie failed to timely report the leak to the trial court or prosecutor. I only found out about this one recently as well. This guy has a YouTube channel, Brandon Woodhouse. So they say the leak of crime scene photos was not the first time that Relators Counsel were involved in a leak of confidential case materials. In December of 2022, Baldwin sent an email to a person named Brandon Woodhouse, a defendant in an unrelated criminal case, that contained an outline of the discovery materials the state had provided to Baldwin. Oh dear. And that Brandon Woodhouse, because he received this discovery outline, oh, he still got it in his possession. And if you go look for his YouTube channel, not now, stay here now, but he's got a YouTube channel and he's got some interesting videos out there where he says a few things about the prosecutor and the former mayor. We've flagged them a little bit here and there, just like, ooh, red flag. And he's saying a few things there that's, if any of it's true, is quite interesting. So they said in December 2022, so Baldwin, you see, he was trying to send it to Bradley Rosie, but then sent it to Brandon Woodhouse, and it's because he was Brandon Woodhouse's defense attorney. But so it was, you know, when it autofills, freaking Bill Gates. It's not Bill Gates' fault. He just it was something that just auto filled out the email address and he sent it and it went to the wrong guy. So they said Baldwin apparently intended to send the email to Rosie. Baldwin and Rosie did not promptly notify the trial court or the prosecution of this leak. Baldwin and Rosie made extrajudicial statements that had a substantial likelihood of materially prejudicing the case. I don't know about that, man. We read through that press conference before. Not press briefing, sorry, that they released after the gag order. It wasn't super shocking or whatever they're accusing them of here, in my opinion. If you didn't see it, check it out somewhere there on the playlist. Barbara says the main point is within this argument is the gag order was in place. Yes. Now they say here, Indiana Professional Conduct Rule 3.6, Baldwin and Rosie issued a press release on November 29th, 2022. They included in their press release detailed extrajudicial statements about the case, along with other information that would not normally be revealed, and proclaimed the relator's innocence. Baldwin and Rosie did not limit their press release to information that Rule 3.6b expressly permits, nor did they confine the press release to information necessary to mitigate adverse publicity under Rule 3.6c. Baldwin and Rosie knew or should have known that the press release potentially violated Professional Conduct Rule 3.6. Moreover, at the time of the press release, Baldwin and Rosie knew that the state had filed a motion for a gag order which was pending before the trial court. Okay, so it was still pending. They saw the opportunity. I don't know. Prior to issuing the press release, Baldwin and Rosie assured the trial court that they did not intend to try this case in the media. Baldwin and Rosie's decision to issue the press release prompted the trial court to issue the gag order until further hearing. Baldwin and Rosie issued the press release knowing that the trial court would likely soon issue a gag order. It's just, what bothers me is, of course, how nervous the prosecution is about the little bits that the defense are saying. Now, I'm not saying that their conduct was professional, but it seems like don't say anything. I don't know. It just feels like the state's case is weak against Richard Allen, in my opinion. Peter Pronzo says, in most of the U.S. judicial court proceedings, judges have far-reaching power to oversee the cases before them. Constitutional safeguards are far-reaching and open to interpretation. Okay, thank you for that. And Joanna says, but his new supposed defense can go on TV and be interviewed. That's a good point as well. William Liberato and Robert Scremen. So it was Robert Scremen that had been interviewed on TV about the evidence they have against Richard Allen and explaining it. We looked at that before as well. And now he's his defense attorney. So yeah, they could go on TV, yes. Anyway, I hear your point. It makes sense. Wow, good point. I forgot about that. Baldwin and Rosie provided false information to the trial court. Now let's hear what they're saying here. On or about June 20th of 2023, the trial court held a hearing on the relator's motion to reconsider the safekeeping order. At the hearing, the state presented evidence that clearly demonstrated the falsity of the relator's claims. The trial on July 19th, 2023, that's about around the time when that other inmate was writing letters and saying that Richard Allen was being abused in the prison, right? So on July 19th, 2023, the trial court issued an order on the motion finding that the evidence presented at the hearing did not support many of the allegations advanced by defendant counsel. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility. I remember that. Caroline says, if the order was pending or was not in place, are people supposed to obey orders before they are given? Right? They were like, listen, they did not obey the order that was pending. There was a motion filed and they knew it was coming. So they should have already obeyed it before it was in place. Yeah, that doesn't make much sense, right? So they didn't do anything wrong at the time, is the point. So as of these events, the trial court became gravely concerned with the relator's rights to have competent, non-negligent representation. The record demonstrates that the trial court, based on the totality of circumstances, could reasonably conclude that counsel's representation of the relator fell objectively short of the prevailing professional norms and that counsel's deficient performance, way to ruin a career, right, prejudiced the defense in violation of the relator's Sixth Amendment right to competent counsel. Ooh, I think they're going to respond with some spicy things. So they say here, counsel is ineffective where, 1, the counsel's performance was deficient based on prevailing professional norms, and 2, the deficient performance prejudiced the defense. I think they're going to throw that right back at Judge Gull. What do you think? Yeah, the Angel Rock says, even where Richard Allen is being housed is not right. I mean, that's not normal. He can go to the Cass County Jail, can he not? So the professional norms in Indiana are violated when counsel fails to safeguard confidential case materials, provides false information to the court, and makes extrajudicial statements that are likely to prejudice the case. But this false information to the court would be, Richard Allen, when they had that picture of him with like I don't know if it was like drool on his shirt or what's going on there. They're saying that he actually had a whole pile of shirts and that this was a picture where he was posing like that. I don't know. How do we know, though, that it's factual that he was not in any way being abused? I mean, I really thought when they brought up the odinous patches that the correctional officers were wearing, I thought that's going to be a load of crap, but it turned out to be true, which is so odd. Which obviously got everyone thinking, well, wow, what the defense is saying is happening to Richard Allen, what this other inmate is saying is happening, might actually be happening. How do we know it isn't happening? I think everybody's worried. I mean, many of us are worried that he's not going to make it to trial. He's lost half his body weight. Of course, he's not drinking alcohol anymore. People say that as well. He's lost weight because he's not drinking beer or whatever. Sure. Some of those could be valid arguments. But he's looking in a state. He looks like he could be losing his mind, as they say. And so everybody just wants him, the suspect, to have a fair trial, but also to be able to make it to the fair trial. Wow. Okay, so Kerry says, yet Judge Gull is happy to walk back convictions of SAers. That is out there as well. That has happened. That's not just rumor. Very interesting. So here they say, okay, the professional norms are violated when they fail to safeguard the materials, provides false information to the court, and makes extrajudicial statements that are likely to prejudice the case. And the respondents filing complaints against Baldwin and Rosie with the disciplinary commission would not have ensured that the relator, Richard Allen, would receive competent representation throughout the remainder of the proceedings. The trial court's decision to remove Baldwin and Rosie did not violate the relator's Sixth Amendment rights. So it's kind of just saying that over and over again. It didn't. It didn't violate it. It just didn't. Or did it? Phantom said, I'm worried about it all. It's very confusing and sick. Yes. So remember in Naomi Irion's case, the suspect, Troy Driver? I mean, he was not okay in the jail that he was being held in. And while he was on suicide watch sometimes, other times he wasn't watched very closely, and he ended up not only attempting to take his own life 3 times, but he actually eventually took his own life. That's also the last thing that anyone wants. To have true justice for the victims. This needs to go to trial. It needs to be a fair trial. No crooked judges, no crooked prosecution, no crooked defense. If that's the suspect, let's just get there to a fair trial. And here, all the facts. Of course, we are not the jury. The jury, an impartial jury, hopefully, will have to hear everything and decide for themselves. What do they think? Is Richard Allen guilty or not? Right, so we're on page 16 out of 23. The trial court afforded the relator adequate notice and an opportunity to be heard before removing his counsel. I think that's an absolute lie. That's not what happened. That is not what happened. It was like there was a hearing for October 31st. And then Judge Gull said, okay, we'll have a hearing on October 19th. And we were all like, wait, oh, there's another hearing. And that hearing, in the paperwork, said it was to discuss recent events, whatever recent events had happened, which means the leaks and things like that. But it wasn't clear. It wasn't like we're going to be basically having a disqualification hearing. So I disagree with that. Yeah, Janet says, and no mistrial. Exactly, and no mistrial. Pernille says, fair process. So the relator argues that removal proceedings should occur at a hearing. Richard Allen argues that removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. The relator cites no Indiana rule, statute, or case requiring notice, a hearing, or an opportunity to be heard. Do they need to cite it? Isn't that just law? In any event, the record confirms that the respondent, Judge Gull, provided Richard Allen with ample notice that the trial court was considering disqualifying Baldwin and Rosie before October 19th, 2023. No, it was off the record phone calls. There's not ample notice. Nicholas McClellan said the word disqualification. Bradley Rosie said, listen, I've heard him say the word disqualification. Is that what's happening here? That's what they said in the transcripts on October 19th. They had no idea that they were going to walk into an actual disqualification hearing, according to what we've read. Am I wrong? This is the whole issue, is that they didn't have notice to prepare, because if they did, they would have prepared to then, argue with what Nicholas McClellan was going to present in court. And they say, the Attorney General, when he responded, said, McClellan was there, he was ready to basically present the case to not only the court, but the entire world, because it's the one time that the judge allowed cameras in that courtroom, and never again. So, and the whole fleet of law enforcement was there. All the head honchos were there. It's just like this one, I don't know, man. Okay, on October 11th, 2023, the relator, Richard Allen, wrote a letter to Judge Gull requesting that Baldwin and Rosie continue to represent him and acknowledging that the prosecutor was seeking Baldwin and Rosie's disqualifications. And that I would have no doubt about. I'm not a big fan of this prosecutor, if you didn't know. I'm just like, I don't know, man, feeling red flaggy for me. But we continue to just perch ourselves on the fence and look at this and be open to all options, right? Yes, Kerry, you make a good point. So on October 11th, Richard Allen wrote a letter. We read through that letter. So in case you think, did we ever? We did. It's on the playlist, okay? And also it was about Baldwin's disqualification. Rosie has always wanted to stay on the case. He still wants to. That's what he's fighting for, right? On October 12th, 2023, Rosie wrote a letter to the respondent arguing why he and Baldwin should not be disqualified. On the morning of October 19th, 2023, an attorney representing Baldwin filed a memorandum regarding possible disqualification and sanctions. Yes, based on rumor and freaking off-the-record phone calls. Did we know about it? Ask ourselves that. Because remember, there's over 100 documents that have not been made public that should have been, that are confidential for no reason. So there's also that, which I don't see this addressed yet. The point is, did we see any documents, anything that we knew on October 19th? All of us were wondering, what is this hearing about? You know, I was chatting to some people behind the scenes about it, and we were speculating it's probably just to prepare for the October 31st hearing. It's probably a hearing to prepare for another hearing. But then it turned out to be this huge thing with cameras in the courtroom that were allowed at last minute. No, I disagree here with Judge Gull, but they say, on the morning of October 19th, an attorney representing Baldwin filed a memorandum. So why did they do that? Because they had a hunch that something, just in case this goes really badly, let's protect ourselves. Because there were off-the-record phone calls talking about murmurings of disqualification. Barbara Bradley, thank you so much. I really appreciate it. And if you guys are only joining now, this is a members-only stream. If you're watching the video, then it would be a clipping from that members-only stream. So thank you, members, all for being here. Yeah, and Joanna says it was a setup. Okay, so they say here, the relator, that would be, so memorandum regarding, okay, the relator, Richard Allen, had adequate notice and opportunity to argue against the respondent's disqualification of Baldwin and Rosie. When? When did Richard Allen have that adequate notice? He didn't even know what the hell was going on. He was there that day and wasn't allowed in the chambers, which I can understand for safety and all of that, but yet the DOC was there, and he was chained, and he had his shock belt on and all of this, so, you know what I mean? He didn't even get to speak. He just got introduced to his two new attorneys, and that's it. So, I don't know where he supposedly got all this notice, but okay. So, they say the relator had adequate notice and an opportunity to argue. Right. Baldwin and Rosie also had the opportunity to proceed with a scheduled court hearing. Oh. Oh, so after the in-chambers, have a private conversation, gentlemen? Or would you like me to disqualify you in front of all these people? That's what they're referring to. They had the opportunity to proceed with a scheduled court hearing on October 19th of 2023, but chose to withdraw instead. I wonder why. It's because they didn't have time to prepare for the arguments then that McClelland would be presenting. They were caught off guard, in my opinion, right? So, they say here, the supplemental record, at the October 31st hearing, Baldwin and Rosie further argued against their disqualification after filing new appearances, and the trial court afforded them an opportunity to be heard on the record, including via Baldwin's counsel. The trial court afforded the relator adequate process. No, ma'am. Ma'am, no, I don't think so. Not from what we can see over here, right? Tiff Knox says, did the docket say they were there for that day? I don't think so. Sure, this is all very shocking. Quite a mess, huh? 3. The relator's request for this court, by the way, we're on page 17. Of course, the last few pages will be like signatures and stuff, so we're almost there. Relator's request for this court to order the respondent's disqualification fails. So Richard Allen's request to have the judge disqualified fails because the respondent has shown, so Judge Gull has shown no bias or prejudice toward the relator, his current counsel or his former counsel. Are you sure? Because that is not what it looks like from over here. Pernille said no. Just no. The relator's assertion, so Richard Allen's assertion that Judge Gull must be disqualified because she removed the relator's former attorneys is flawed. First, Baldwin and Rosie no longer represent the relator, and the relator does not assert that the respondent has any personal bias or prejudice toward himself or his current counsel. Okay, so once again, you're saying Baldwin and Rosie are irrelevant, and Richard Allen hasn't really told me that he feels this way, that I'm treating him this way. Oh my word. Okay, so they say second, on the merits, the relator, Richard Allen, presents no relevant facts supporting the relator's assertion that the respondent is biased or prejudiced against the relator's former counsel. We could see it with our own eyes. Okay, so a judge shall hear and decide matters assigned to the judge except when disqualification is required, and there's a whole lot of rules and legalese here, right? The Angel Rock, that deserves in all caps. What? Alyssa says, really? Wow, after being intimidated? I know this word gets thrown around a lot, but now it really feels like gaslighting. This is like, it didn't happen like that. They had plenty of time. They were given an opportunity. Like, no, they weren't. No, even if they were, the public would have known about it. We would have all not wondered, what is this hearing on October 19th? What's going to happen? We wouldn't have been so curious about what the hell happened in those chambers. Where's the transcripts? Which they didn't want to release 3 times over and eventually did. And it was an interesting read indeed. So here they say, commentary to the Code of Judicial Conduct emphasizes a judge's unwarranted disqualification compromises the system of justice. Does it now? I don't know. It feels to me like this case could do with a reset. New judge, maybe new attorneys, new prosecutor would be great. New state. That would be amazing. My word. Try it somewhere else. Sure. Unwarranted disqualification may bring public disfavor to the court and to the judge personally. Okay, I do not think that if Judge Gull is forced to recuse herself, that would bring public disfavor. I think majority of the public, of course, there's many different thoughts, and tribes out there thinking different things and very set in this is what I think happened here. And here we're trying to have a discussion about this. Right? I just don't think that majority of the public would think, oh my word, like that this would bring public disfavor to the court and to the judge personally. Don't worry, it already looks bad. This is not going to make things look worse. It's not going to be a bad PR move if this judge recuses herself. It's already been bad. It can't really get any worse, in my opinion. The dignity of the court, the judge's respect for the fulfillment of judicial duties, and a proper concern for the burdens that may be imposed upon the judge's colleagues require that a judge not use disqualification to avoid cases that present difficult, controversial, or unpopular issues. Remember when the judge said that she doesn't want to put the motion for a Frank's hearing on the court system site, the document, because it's got the names of the victims in. Like, lady, this is the highest profile case probably in America. Never mind like Delphi, Indiana. It's a huge case. It's been a rocky road. Everybody knows the names of the victims and everybody's fighting for justice for them. Rochelle Pronzo says, Gull should just fly the coop. It's quite ironic that now she's fighting for her job. That's exactly what the defense attorneys were doing. Isn't it quite ironic to see this happen now? Just a crazy Swifty says, when you hit rock bottom in Delphi, you just start digging. Yeah, it seems that way, right? The law presumes a judge is unbiased and unprejudiced. Until they aren't. To overcome this presumption, okay, so now they're giving a lot of legal reference, all right? A, Baldwin and Rosie no longer represent, yes, we know you think they're irrelevant, right? They no longer represent the relator, and the relator alleges no bias toward himself or his current counsel. But the thing is, Bradley Rosie never submitted his written motion to withdraw, and therefore it's still a bit of a grey area, even though the judge is saying, because I said so, you're out. The respondent removed Baldwin and Rosie from representing the relator on October 31st, 2023. And I think it was right after that she started feeling very unwell and went to the hospital and started working from home. So it must have been a very stressful day. The respondent appointed new counsel. Obviously, I'm assuming. I don't know what the issue is. I don't know if it's COVID or something else or stress. We don't know. Okay. The respondent appointed new counsel, Robert Scremen and William Liberato, to represent the relator. The relator is represented in this original action by Mark Lehman and Cora Weinecker. The relator accuses the respondent of exhibiting bias or prejudice exclusively toward Baldwin and Rosie. The relator never suggests that the respondent is biased or prejudiced against the relator or his current counsel. Given that Baldwin and Rosie are no longer counsel of record, the relator's sweeping assertions that for all rulings going forward, the public will question the judge's impartiality, and that a new special judge must be appointed to restore the public's trust in the integrity of the judicial process, amount to blind speculation. I object. I do not think it amounts to blind speculation. I think this is a very valid statement. I think that public trust has been lost. It's on shaky ground, and it could be time for a reset. Good luck to that judge. If they're going to get a new special judge, ooh, you're going to have so much kahunas. You're going to have a strong backbone. You're going to have to be so ready for the biggest case of your life. I mean, there is a lot of pressure, of course, on this case. That's also Judge Benjamin Diener recused himself, saying he wants to keep his family safe and that this case is just like, it's so overwhelming, right? Okay, so B, the relator fails to show that the respondent has actual bias or prejudice against Baldwin and Rosie. Oh, Richard Allen didn't demonstrate that enough. We hear it loud and clear, though. Even if Baldwin, I can't speak for everyone. Of course, some people feel differently. I could just see the majority of comments here, and I'm like, and in general, on many of our live streams, in general, it just seems like we can see how you feel about Richard Allen's former attorneys and possibly even about Richard Allen. Anyway, so they say, even if Baldwin and Rosie still represented the relator, the respondent has exhibited no actual bias or prejudice against them. But I would argue that having the entire fleet of law enforcement there, all the head honchos, Tobe Lesenby and Duck Carter, and I actually didn't see Tobe, did we? I think he was actually there later when they walked out. But anyway, the whole fleet of law enforcement, okay? Nicholas McClelland now has he's got assistant counsel. I think that's what it's called, right? He had another dude sitting there next to him. Like, okay, join the team. Cameras. Suddenly there's the media allowed for the first time in the courtroom. That in itself is representing or exhibiting this no actual bias or prejudice against them. That's a lot of action that was taken there. The relator offers a scant 2 sentences to support his assertion that the respondent has exhibited bias or prejudice. According to the relator, that's Richard Allen, the respondent's finding the counsel were grossly negligent and publicly proclaiming that she had grave concerns about their representation warrant the respondent's disqualification. But a judge's findings adverse to a party do not show or even imply bias or prejudice. Further, these findings do not demonstrate actual personal bias. The respondent did not state that she had grave concerns about Baldwin and Rosie personally. Rather, she had concerns only about the representation of the relator and his right to competent representation. All right, okay, so the respondent's legal findings regarding Baldwin and Rosie's representation are insufficient. Okay, Judge Gull's legal findings regarding Baldwin and Rosie are insufficient to overcome Indiana's law presumption that the respondent is unbiased and unprejudiced. Referencing things again. Wow, we're almost there and my voice is still holding up. The court should deny the relator's request to reinstate the trial date. Oh, sure, let's just keep it going. Let's just add another year to it, right? Anyway, so the relator requested the continuance. They say the relator requests that this court to reinstate the January 2024 trial date. Remember that Bradley Rose is ready to go. So is Richard Allen. They're like, let's do this. Let's go. January 8th, right? So they say the relator requests this court to reinstate the January 2024 trial date. But the relator's counsel requested the trial continuance because counsel will not be ready to try the case in January. Yeah, the new counsel weren't. Bradley Rosie would be ready. The respondent did not violate an absolute duty by granting the relator's own motion. Then, the court should deny the amicus's request to refer appointment of replacement counsel to the state public defender. Amicus Indiana Public Defender Counsel, IPDC, argues that the trial court's appointment of the relator's current counsel was procedurally defective. Exactly. Did you guys remember that? We read through that. It's not just the Indiana Supreme Court that is now looking at this. It was also the Indiana Public Defender Counsel. They were also saying that the trial court's appointment of Richard Allen's new counsel was procedurally defective, but the relator raises no objections to the respondent's process for appointing new counsel to replace Baldwin and Rosie. I think it was clear that he doesn't want that, and neither do they, and there's still a grey area because he didn't file his written motion to withdraw. Amicus may make arguments in support of the relator's request for relief, but the court should not entertain amicus's separate request for relief. So they're like, listen, they're allowed to complain, but listen, just ignore them, okay? That's how I read that. Sorry, sometimes I interpret it in ways. So what I do for myself, that we can really understand, like, what is going on here. And I hope I'm getting it right. Neither the IPDC nor the relator, Richard Allen, assert that the relator's newly appointed counsel, one of whom, as the IPDC notes, is Allen County's chief public defender, is incompetent. Why are you choosing, that's another thing, 2 new attorneys from Allen County? Even that is what the IPDC brought up. Do you remember? Isn't it so hectic? Just ironic wordplay that it's Richard Allen and the special judge from Allen County and the 2 attorneys from Allen County. It's just like, that's a lot of Allen. The IPDC merely claimed that the trial court circumvented the county's comprehensive plan for public defender assignments. However, the trial court has discretion to appoint counsel other than counsel provided for under the board's plan when the interests of justice require. The trial court's method of appointing the relator's new counsel did not violate Indiana law, the Sixth Amendment, or any other absolute duty under the law. Conclusion. The respondent, the Honorable Francis C. Gull, respectfully requests that this court deny the relator's verified petition for writs of mandamus and prohibition. And let's go to the last page. Oh, we've got the verified statement of word count. All right. And the certificate of service. So we've got through that document. So let's wait to see what the Supreme Court comes back with. So thank you so much for watching this with me. I really appreciate it. If you are not yet a member and you want to join these member streams where sometimes we are looking at things as they come in, then you can go to grizzlytruecrime.com. All the links are there for all the different types of ways to support the channel. So thank you so much for watching, and I will see you in the next one. Stay safe.